Laura, and I work in compliance at BackTrack. If you have any questions you'd like to ask during the webinar, type them into the question pane. We'll answer them at the end of the webinar. The webinar will also be recorded and available on our website later this week. I'd like to turn the presentation over now to Jonathan Hyman. He's a partner at Meyers Roman, specializes in labor and employment law. John's also an author and a noted blogger in the employment law field, and we are thrilled to have him present this webinar. So John, take it away, please.
Great. Thank you, Laura. I'm thrilled to be with everybody today. Good afternoon, everybody, or if you happen to not be on the East Coast or Eastern Time, good morning, I suppose. As I said, it's good to be with everyone for the next hour. We'll be talking about adverse actions under the Fair Credit Reporting Act, which in a moment we're going to get to why this topic should scare the pants off of everybody listening today. And we're going to give you some valuable information on what you need to do to stay out of the crosshairs of what is turning into a very, very lucrative area of litigation for the plaintiff's bar, which is, as a defense lawyer, is great for me, but as someone who advises...
Hey, John, quick thing. I apologize. I'm getting messages that it sounds very muffled and hard to hear on your speaker.
Oh. Okay. Let's see if we can fix that. I think I need to. Let me see. Is this better for anybody? Can you see if people respond if they can hear better now?
I can hear much better on my side, too.
Okay.
Yes. Everybody's saying it's perfect.
Okay,
Sorry about
good. That. Very good. Okay. Then on we go. I want to start out with a little story for everybody, and this slide will make sense for everybody in a second. My grandfather, when I was growing up, really for his whole life, spent a lot of time in bars, and it wasn't because he was a serious drinker or liked to drink, although he did, but he owned taverns for, that was his career. For his entire life, he owned bars. And we're not talking the, high-end, gastropub with the, designer beers and high-end bottles of wine or what have you. We are talking hardcore beer and shot bars in neighborhoods in Philadelphia where you would not feel comfortable walking around in broad daylight, let alone at night when most of his customers would come into the bar. And being that he spent, 60-plus years in the bar business, he did like to have the occasional cocktail. More than occasionally, he would have one, maybe two martinis with dinner or before dinner every night, as far as I can remember. And when I was, 10, 11, 12 years old, he retired out of the bar business, moved down to Florida, where we would go every winter break to visit, where he would continue his habit of his martini or two before dinner every night. And lived in a retirement community in Florida, and would, every now and again have friends over from the neighborhood to join him in these pre-dinner cocktails. And on his bar, in the sunroom in the back of the condo, there he kept a bottle of Absolute that he would use to mix drinks for him and his friends when they would come over. So we're down there in Florida one December. I was probably 12, 13 years old, and his friend was next door neighbor was going to come over for their pre-dinner martinis, and goes over to the bar. And lo and behold, before his friend gets to the house to start getting the drinks ready, lo and behold, the bottle of Absolute was empty. And so he takes a step over to the closet in the sunroom where I thought he was going to get another bottle of Absolute. And instead what he got was, it might not have been Popov, it might have been some other, pick your bottom of the basement vodka that comes in a very, very large plastic jug and a funnel. And there he filled up the bottle of Absolute, what had been empty, which was now filled to the top with what was definitely not decent vodka, but was very, very lousy drugstore well vodka. Friend came over, mixed the drinks out of the bottle of Absolute, and they went about their business. So why do I tell you this story in a webinar about the Fair Credit Reporting Act, background screening, and adverse actions? When you hire employees, on paper they all look the same. In a bottle of vodka, or in a bottle of booze, right? Vodka all looks the same. It's a clear liquid, and on paper, your employees, your applicants are going to appear to be exactly the same. You're not going to be able to tell them apart on paper. You may not be able to tell them apart when they sit down at you across a desk in a job interview. You need to engage in some diligence. You can find out exactly who it is you're hiring before you invest time and resources in actually making a hiring decision and onboarding an employee, which is where background checks come into play. We want to know who we're hiring. We want to know whether they're honest, whether they're truthful, whether their resumes are accurate. We want to know, if they went to school where they say they went to school. For certain positions, we may want to know if they're financially responsible. For certain positions, for most positions, we may want to know if they have a criminal background. And people might not be honest and forthright and open with you about these, which is why we engage in background checks to find out exactly who it is we are hiring before we go about and hire them. Unfortunately for you, however, as users of background information on applicants, this is a highly regulated industry, screening industry. There's a federal statute in place, the Fair Credit Reporting Act, that highly regulates both when and how you can use consumer reports, and we'll talk in a second about exactly what that means and what exactly you have to do to go about obtaining consumer reports on applicants and employees from consumer reporting agencies. And these are terms that we'll define in a few minutes. The Fair Credit Reporting Act is not a new statute. It's been around since the early 1970s. It was enacted to help regulate how and when companies could get initially credit information on individuals to protect some individual privacy rights. There was a kind of a hole in the laws whereby this industry before that was really not regulated, and if there was untruthful information in one's credit report, it became very, very difficult to discover that and then to correct it. And so Congress stepped in, passed the Fair Credit Reporting Act in 1971. In 1996, the statute was amended, which primarily, for our purposes today, impacted how employers go about obtaining and using these consumer reports on employees and job applicants. And then the statute was again amended in the early 2000s to address some issues regarding identity theft and other things. Most recently, in 2013, the FTC, the Federal Trade Commission, ceded authority of enforcement of the Fair Credit Reporting Act to a new agency known as the Consumer Finance Protection Bureau, which as of January 1, 2013, took on enforcement of this statute. But aside from that, background checks have been in the news a bunch, primarily in the area of criminal background checks. April 2012, EEOC, the Equal Employment Opportunity Commission, enacted new guidelines for the use of criminal records in hiring. We'll talk about that later on in the presentation. A few months thereafter, the Today Show ran a highly publicized expose on the background screening industry. Shortly after that, we had the formation of the Consumer Finance Protection Bureau, which took over enforcement of the Fair Credit Reporting Act from the FTC, and then 60 Minutes picked up the baton from the Today Show and ran yet another expose on this industry in 2013. And all of this kind of information that's out there about the consumer reporting industry, the background screening industry, has led to the sharks circling, and by the sharks I'm talking specifically about the plaintiff's bar, which has really seized on an opportunity to make life very, very miserable for both employers and businesses in the background screening industry. You can read the trades just about every week and learn of a new lawsuit that has been filed claiming a violation of the Fair Credit Reporting Act. Whole Foods is one, Panera is one, Dollar General is one. I just read this morning that Pizza Hut of America has just been sued in a class action under the Fair Credit Reporting Act. And we're not talking small dollar lawsuits. Just in the last 18 to 24 months, Kmart paid a $3 million settlement of a class action under the Fair Credit Reporting Act. Domino's Pizza paid a $2.5 million settlement. Swift Transportation, a $4.4 million settlement. Dollar General, a $4 million settlement. Public Supermarkets, a $6.8 million settlement. These are big ticket, big stakes lawsuits. And the reason why plaintiffs are so interested in them, as we're going to learn in a few minutes, this is a highly technical statute under which it is very easy for employers to make mistakes, and the mistakes are largely black and white. You either follow what the statute says you have to do when you procure a background check on an applicant or an employee, and when you take an adverse action against them, or you don't. And there's not a whole lot of gray area. There's a little bit, but not a ton. You're typically talking about, specifically with big employers like Dollar General or Whole Foods or Pizza Hut, you're talking about large classes of individuals, and you're talking about a statute with mandatory penalties, which we'll talk about later on in the presentation, and fee shifting. The plaintiffs' lawyers get their attorney's fees if they're successful in the case. And so when you put in a combination of kind of black and white issues, big classes of people, and fee shifting, you get kind of the perfect storm for plaintiffs' lawyers to swoop in and make life very, very difficult for businesses under this very, very technical statute. When you add that to the mix of the Consumer Financial Protection Bureau, which has now taken over enforcement of this statute in a highly regulated industry and a highly politicized regulatory environment in D.C., that kind of completes the picture as to why this is an issue that employers really, really need to pay attention to make sure if they are running background screens on applicants and employees, they are doing it 100% correctly, because even the most nitpicky of violations, and we'll talk about what those violations could be, even the tiniest of violations would likely be carried across a company's background screening program and could lead to big dollars, which I can guarantee you do not want to have to pay out to a group of employees and their lawyer or lawyers. Talked a little bit about the Fair Credit Reporting Act and its history. Again, we're not talking about a new statute, but we're talking about a statute that employers, if they have not paid attention to it before now, need to pay attention to it now, because it's a statute, as I said, that has gotten, particularly with a lot of the high publicity lawsuits and stories in the last few years, has gotten the attention of the plaintiff's bar, which means it absolutely has to be on your radar. Let's talk some definitions, what we're talking about here, so we understand the framework of the statute that we're talking about. The Fair Credit Reporting Act, and it's such an unfortunate name because it talks about, it has credit in the title, so a lot of people make the mistake in thinking that it only regulates credit reports. That is, the FICO score with the report that you get for one of the three credit reporting agencies, credit reporting bureaus. That's not true. The Fair Credit Reporting Act regulates all consumer reporting agencies, and we're not just talking about Experian, TransUnion, what have you. We're talking about any person or agency that assembles consumer credit information. And by consumer credit information, we're not talking, and again, while they use the term credit, they're not just talking about credit. They're talking about any background information really on an individual at all. So it could be credit information, what we traditionally think of as someone's credit history or credit background, but it could also be criminal histories. It could be it's really any information that bears on one's reputation is considered that's gathered by a third party, the third party being the consumer reporting agency. The end user is the person that has the permissible purpose to access these records in the employment process. That is, the employer would be the end user of this information in this case, and the consumer, that is the individual protected by the Fair Credit Reporting Act in regards to an employer obtaining this background information, is the applicant or the employee. The permissible purpose is under the Fair Credit Reporting Act, one can only obtain a consumer report, and we'll talk about what that means in a second, for a permissible purpose. If you don't have a permissible purpose to get the information, the statute says you can't get it. And particularly for your purposes, the permissible purpose is an employment purpose. The Fair Credit Reporting Act defines as a permissible purpose an employment purpose, that is hiring, firing, promotion, anything having to do with an employment. The Fair Credit Reporting Act says an employer, as a user of the information, has a permissible purpose to obtain the information. And then what exactly is the information that we're getting? We're getting information in a consumer report from the Consumer Reporting Agency, and the consumer report is any written or verbal report about a consumer, that being the employee or applicant, regarding one's fitness or worthiness for employment, which includes not just the traditional credit reports that we think of when we think of credit, right? But also criminal records, driving records, verification of employment, educational records, again, anything bearing on one's character, fitness, reputation, etc. If it's compiled by a consumer reporting agency that is a third party that's in the business of gathering this information, it's going to be deemed to be a consumer report. Why we are here today is to talk about adverse action, and that also has a definition of meaning under the statute. It's any action taken by the end user, that is the employer, that has a negative impact on the consumer being the employee, such as a denial. The statute defines it. I love how Congressman Wright. Denial, cancellation, or unfavorable change in employment status, including hiring, promotion, firing, etc. What are we talking about? Really, it's anything that impacts negatively on an applicant or employee. If you deny hiring, if you don't hire someone, that's an adverse action. If you fire someone, that's an adverse action. If you don't promote someone, that's an adverse action. And that's going to impose on the employer, specific requirements under the statute. What requirements are we talking about? There are 6 hoops that companies must jump through when obtaining and using consumer reports from a consumer reporting agency. If you are getting background information from a third party that is in the business of compiling this information, such as BackTrack, you must. It is not discretionary. There is no wiggle room. You must follow each of these steps to the letter, or you will find yourself as the next Dollar General or Panera or Whole Foods or Pizza Hut as a named defendant in a class action lawsuit under the Fair Credit Reporting Act. And we won't be talking on a webinar. We'll be talking when you say, I've just been sued, oh my God, what do I do? And believe me, I'd much rather, for your sake, I'd much rather be talking to you all today to help you proactively avoid getting sued and talking to you after the fact. These aren't complicated hoops to jump through, but they are hoops nonetheless that you must jump through. And if you miss one, you might as well miss them all because it's not going to make a lick of difference. Step number one that you must follow when you are seeking to obtain a consumer report from a consumer reporting agency, and for the sake of brevity, I'm just going to talk in terms of background checks now, and hopefully we understand that when I'm now referring to a background check, I'm talking about a consumer report from a consumer reporting agency as we previously defined them. When you're looking to get a background check on an applicant or employee, step one is notice. You have to give them notice that you are going to be running this background check on them. What kind of notice do you have to give them? It has to be clear and conspicuous. What do we mean by clear and conspicuous? In the courts that have looked at whether a notice under the Fair Credit Reporting Act is sufficiently clear and conspicuous, courts look at things like, is it written in plain English? Is it put in a font size that won't be buried in another document? Is it are bold letters used? Are all caps used? Is it easy for someone to find it, read it, and understand it? And it must be in a document completely separate from everything else, including the employment application. So if your employment application says, and you understand that by applying for employment, we may run a background check on you, including credit, criminal history, whatever, and by signing the application you consent that you understand and consent that we have the authority to do this, you violated the Fair Credit Reporting Act. When the statute says separate, clear, and conspicuous, it means separate, clear, and conspicuous. You can't use your job application, you can't bury it or even try to make it obvious in another document. It has to be in its own standalone document, all by itself, clear, conspicuous, plainly written, explaining to employees that that you will be running a background check, that you will be getting a consumer report, explaining to them what that is from a consumer reporting agency, explaining to them what that is in language they can understand. If you bury it in a stack of documents, if you put it in small print at the bottom or back of another piece of paper, courts are going to find that you have violated the Fair Credit Reporting Act. There is a subset of consumer reports under the Fair Credit Reporting Act called investigative consumer reports. We're going to talk a little later about what that is, but just to foreshadow a little bit, you need to understand that if you're getting if you're seeking to run an investigative consumer reports, there's even more notice that you have to give the applicant or employee other than just notice of the background check itself. So additional steps you have to run if you're doing an investigative consumer report, and stick around. We'll talk about that in a little bit. Step two is consent. So you've now given the notice in a separate, clear, conspicuous document. Step two, you now have to get the applicant or employee's written consent for you to run the background check. It has to be in writing. It has to be signed by the applicant or employee. It's okay if it's partnered with the notice. So the notice itself has to be separate, right? You can't bury it in another document, combine it with the application, do other things. But the consent can be on the same document as the notice, as the disclosure notice. That's okay, so long as the whole document, the notice and the consent, is all on a separate document from everything else you're giving the employee or applicant. It's okay to combine the written authorization, the consent, with the notice. Evergreen is okay. It is okay for employees to give your applicants to give their consent for you to run a background check at any time during their employment, as long as you make it clear in the document that that's the consent that they're giving. It's okay to tell employees or applicants that, look, if you don't give your consent, I'm sorry, but we can't hire you. Running the background check is in fact a condition of employment, and if you don't want us to run the background check, that's your right, but it's also our right to decide to no longer consider you for employment. One other point I want to make is that what a lot of employers do or try to do is include with the notice and consent form either some kind of indemnification language that the applicant holds the employer harmless for any violations of the Fair Credit Reporting Act, or kind of release and waiver language that the employee is releasing the employer, or the applicant's releasing the employer from any potential liability under the Fair Credit Reporting Act. That is also a violation of the statute. You can't do that. If you not only would the release be invalid, but it would also subject you to, as a violation of the statute, but it would subject you to liability under the statute for putting something in the notice, disclosure, consent form the statute forbids you from doing. So clear, conspicuous, separate, written authorization signed, evergreen is okay, and it's probably recommended. So every time you want to do a background check on an individual, you don't need to go get their consent again. And it's okay to let people know that if they don't sign, thank you for playing, next contestant, please. Step 3 in the pre-hire background check process is your certification to the background screening agency, to the consumer reporting agency, that you have done 4 things. That you've provided this separate, clear, conspicuous notice to the applicant, that you've obtained the applicant's or employee's consent to run the background check, that you've complied with the Fair Credit Reporting Act, and that you will not discriminate against the applicant or employee or otherwise misuse the information that's returned by the consumer reporting agency in the background screening process. This is something that your background screening company should be working with you on, and if you are working with a background screening company that is not having you follow the certification process, then you should probably look for a new background screening company, because these are the kind of things that I know BackTrack tells you, and it's the kind of things that any reputable background screening company will tell you, because nobody should be releasing information to you without you providing the certification to the company that you followed each of these steps. Step 4. So we've now provided the notice, the disclosure, we've gotten the consent, we've made the appropriate disclosure to the consumer reporting agency. We're now at the point where we've gotten information back from the consumer reporting agency on an applicant or an employee, and we review the information, and we've now decided that based on the information we've received, this may not be somebody we want to hire. You cannot, or somebody we want to fire or take another adverse action against. You cannot at that point, however, make your final decision. The Fair Credit Reporting Act makes it a 2-step process. There is a pre-adverse action process and there is an adverse action process. And if you don't follow them both, again, you have violated the statute. The pre-adverse action process requires you to provide notice to the individual of your that you may take an adverse action against them based on information that was returned from the consumer reporting agency. You have to provide them a copy, an actual copy of the report that you may rely upon in maybe making that adverse action in the future, and you have to provide them a copy of a document that's available from the CPFB entitled Summary of Your Rights Under the Fair Credit Reporting Act. It's a PDF that you can download directly from the agency's website, or you can get it from, if you want to email me or email your contact at BackTrack, any one of us can get you the document. It is a pre-drafted PDF that's available right from the government. why do we go through this pre-adverse action process? We need to think back to why the Fair Credit Reporting Act was enacted in the first place, and what it is that Congress was trying to regulate here. They're trying to prevent entities from making decisions about individuals based on inaccurate information in one's background. Identity theft is a big problem. I went to law school with a girl that had to wait 6 months to take the bar exam because when she applied for the bar, someone had misappropriated her identity, and she had 3 felony convictions, 3 felony warrants out for her arrest because someone was using her Social Security number. It happens. It doesn't happen that often. It's definitely the exception and not the rule, but it does happen when a background check turns up incorrect information. Either there was something misreported in something in a report because of identity theft, for example, or information is returned on the wrong person. It happens. And so this pre-adverse action notice, by letting someone know that we may take an adverse action against you based on information that was returned in the background check, gives the individual the opportunity to challenge information, explain away negative information, either if it's truthful information, give you an explanation, or if it's incorrect or untruthful information, dispute it and explain to you, that's not me, I didn't do those things, you have a mistake, I'm not that John Smith, or what have you. And so the pre-adverse action notice fulfills the purpose of the statute by giving the individual the opportunity to dispute, to challenge, to explain. And for that reason, after you give the pre-adverse action notice, you have to wait, and that's step 5, the waiting period. Between the pre-adverse action notice and actually taking the adverse action, letting the individual know that you've made the decision and are not going to hire them, you're rejecting their application, you're firing them, you're denying their promotion, whatever it may be, you have to wait. And in the opinion of the FTC, which drafted opinion letters and drafted regulations before the CPFE took over, the opinion is that 5 business days is a reasonable amount of time to wait. Again, the purpose here is to allow the individual, the consumer, to dispute the accuracy or completeness of the report before the adverse action is taken. And the reality is many employers trip up in this part. They make a mistake by contacting the individual by phone before giving them the pre-adverse action notice. So you get back the consumer report on the individual, you pick up the phone, your HR, hiring manager, whomever, recruiter picks up the phone and calls the person and says, we got back your background check. Unfortunately, we have a policy against hiring felons. Thank you for playing. And then you say, oh, but your steps kick in, right? You then send out the pre-adverse action notice. But at that point, what courts almost universally say is if you contact the individual before sending out the pre-adverse action notice, it makes the decision look like a fait accompli, that you've already made up your mind. You've already taken the adverse action by notifying the individual, and therefore there was no pre-adverse action notice because your mind was already made up. And if your mind's already made up before you send out the pre-notice, then you've skipped the step. You skipped over the pre-step and gone right to the adverse action. And courts in that instance are going to say you violated the statute by not your pre-adverse action notice is really the adverse action notice because you've already made up your mind. So you want to make sure all your people that have contact, have knowledge of the background screening results and have contact with applicants or employees, understand that this process is here for a reason, it has to be followed, and they should not be communicating with applicants about decisions before that pre-adverse action notice is sent and the 5-day waiting period has elapsed. when we talk about criminal histories, the CPFB is not the only agency that is regulating here. The Fair Credit Reporting Act is not the only statute that is regulating what employers can do with criminal histories. I just want to touch on this issue for a second. But the EEOC, the Equal Employment Opportunity Commission, has also gotten very active in the area of regulating what employers can and can't do with criminal conviction history information when making employment decisions. We know that minorities, specifically Hispanics and African Americans, are disproportionately represented in the category of those convicted of a crime in this country. And for that reason, the EEOC takes the position that if you have policies that preemptively and automatically screen out felons from employment, that policy will likely have an adverse impact on Hispanics and African Americans, and adverse impact is one way you can violate the employment discrimination laws, Title VII. You don't necessarily have to intentionally discriminate, but if you have a neutral policy like we don't hire felons that disproportionately impacts one race over another, that policy, unless you have an overriding business justification, is going to violate Title VII as well. And so the EEOC a couple years ago put out some enforcement guidance in this area, telling employers a couple of things of note to make note of here. Number one, for example, the EEOC does not like questions on employment applications that ask individuals whether or not they've ever been convicted of a criminal offense. The so-called ban the box movement, the EEOC wants that box taken off of job applications. Some municipalities and states have already enacted legislation to this effect. But the EEOC takes the position that if someone checks yes on a job application and you automatically disqualify that individual from employment because they say they've been convicted of an offense, that you have you violated Title VII by engaging in a practice that has an adverse impact on minorities. In my view, you have that box on there on an application for a couple of reasons. Number one, you don't just want to know whether or not someone's been convicted of a felony, but you're testing someone's veracity. Is someone going to be honest with you up front in the hiring process, or are they going to check no only to have a background check come back later and reveal that they lied to you, number one. And number two, you're really, in my view, just increasing transactional costs on employers by, if you tell employers that you cannot have that box on an employment application, but the employer nevertheless is not going to hire someone who's been convicted of X, Y, or Z, you're making that employer now run a background check on that individual to find out whether they have this disqualifying criteria in their background, which greatly increases the transactional costs associated with hiring an employee. So it's my editorial soapbox for 30 seconds. The other issue that the EEOC is attempting to regulate in this area is requiring employers to engage in an individualized assessment of anyone that has a criminal history. By having this 5-day waiting period under the Fair Credit Reporting Act, it gives you the opportunity to engage in what the EEOC says is this required individualized assessment, to take into account when you hire someone or when you're considering someone for employment who has some kind of criminal conviction in their background. What's the nature of the offense? How long ago was it? What's the nature of the employment? And when you kind of throw all that in the hiring blender, does it come out as someone that is worthy, having the conviction overlooked and hiring them anyway, or someone that should be disqualified because of the conviction? The EEOC takes the position that if you don't engage in this individualized assessment, you violated the statute because you are just automatically disqualifying anyone with a felony in their background. I think, again, to get on my soapbox for a second, if I'm Domino's Pizza or Pizza Hut and I'm hiring delivery drivers, I don't see anything wrong with saying I don't want anyone who's been convicted of, breaking and entering, armed robbery, or a sex offense from going door to door delivering pizzas. It's just you can make that decision from a kind of a risk assessment standpoint right out of the box without having to sit down and talk to the person and say, why should we hire you to go to our customers' homes despite the fact that 2 years ago you were convicted of breaking and entering. Be that as it may, the Fair Credit Reporting Act's 5-day waiting period kind of gives, after the pre-adverse action notice and before the adverse action, gives employers the opportunity to engage in this type of individualized inquiry, individualized assessment that the EEOC wants employers to do. Okay, so you've given the pre-adverse action notice, you've waited the requisite 5 days, you now are ready to let the individual know that you in fact are not going to hire them or take some other kind of adverse action against them, and so you have to give them the post-adverse action notice. You've now given them the pre-notice, you wait the 5 days, you've made your decision. They've either challenged it or they haven't, but either way you've made your decision, and you give them the post-adverse action notice, which consists of an oral, written, or electronic notice of the fact of the adverse action. You can send them a letter, you can send them an email, you can pick up the telephone and say, we've decided not to hire you, and then written notice that includes the contact information for the consumer reporting agency that provided the information, a statement that the consumer reporting agency did not make the decision, and a notice of the right to get a free copy of and dispute the actual report itself, the consumer report itself, the information that you, the employer, relied upon in making the decision in reaching your adverse action decision. So oral, written, or electronic notice of the fact of the adverse action, and then a couple of things you have to provide the individual in writing, including information about the consumer reporting agency and how they can go contact the agency for a copy of a free copy of the consumer report itself. I mentioned before there's a special subset of consumer reports called investigative consumer reports. These are where you gather information on someone's character, reputation, trustworthiness, etc., not by getting documents or information from publicly available sources like criminal conviction histories, but you actually hire someone to go and conduct interviews, meet with people to gather that information. So, for example, if you are hiring a private investigator to go talk to someone's neighbors about them, or if you are hiring a third party to go conduct interview job references, for example, and are not doing that internally, you would likely be engaging in an investigative consumer report, and there are special steps that an individual or a company has to comply with when they are conducting investigative consumer reports as opposed to a consumer report. All the 6 steps we talked about before already apply. They apply to investigative consumer reports just like they do to consumer reports. There's a couple of extra things you have to do if you're doing an investigative consumer report. The disclosure and the consent up front has to be broader. It still has to be separate, conspicuous, understandable, what have you, but it has to be more broadly written. You have to tell the individual not just that you might be obtaining a consumer report and telling them what that is, but that you might also be obtaining an investigative consumer report for an employment purpose. You have to tell them that that investigative consumer report would entail personal interviews with individuals, and that the information gathered will be about the individual's personal characteristics, reputation, and mode of living. The disclosure must also contain a statement letting the applicant or employee know that he or she is entitled to make a written request for additional disclosure about the report. That is the actual nature and scope of the investigation itself, and that if the applicant makes that request within a reasonable amount of time, which is typically, I think, 5 days, same as the adverse action, the waiting time, the employer must provide a complete written description of the nature and scope of the investigation within 5 days after the individual's request was received or the report was first requested, whichever is later. So what does all that mean? It means that if you have to tell the person they have the right to request a description of the investigation, and if they make that request within a reasonable amount of time, within 5 days, you have to provide them a written description of what the actual investigation entailed, and that could either be a copy of a copy of a form that's used to transmit the information. You have a set of interview questions that are being draft interview questions or what have you, or you can otherwise describe the type of questions asked, the number of people interviewed, and the name and address of the investigating agency. Additional hoops to jump through when you are engaging in a investigative consumer report. Additionally, up front, even before you get the person's authorization, you have to up front give them a copy of the pre-written document, summary of rights under the Fair Credit Reporting Act, and then just like with the consumer report, you have to get their written consent. The adverse action procedures pre and post are exactly the same, but there's just additional disclosures you have to provide the individual about the fact that you are engaging in an investigative consumer report instead of a consumer report. That summarizes kind of what you have to do under the Fair Credit Reporting Act. I want to touch for a second on what happens if you don't do those things. We talked before about some of the lawsuits and how big the damages can be. Two types of liability under the Fair Credit Reporting Act. There's willful violations and negligent violations, but according to the U.S. Supreme Court in a case decided 7 or 8 years ago, Safeco Insurance of America versus Burr, willful doesn't really mean willful. Willful doesn't mean intentional. A willful violation of the Fair Credit Reporting Act also includes reckless violations. That is, or it's so obvious that it should be known that you violated the statute. And the courts that have looked at this willful or reckless standard since the Safeco decision have made it pretty clear that even though the statute uses the term willful, the threshold is pretty low, and that companies that are engaging in background checks, lots of things they should know, such as the 6 steps we talked about, and that violating one of those steps will likely be a willful violation, even if you didn't intentionally violate the statute. The penalties and damages for a willful violation are, the statute talks about basic damages, and it's actual or provable damages to the individual with no cap, or statutory damages somewhere between $100 and $1,000 per violation. One of those two. If there is a real intentional violation, that is the user lied to the consumer reporting agency to get the information or use the information for an impermissible purpose, then it's the greater of the actual provable damages or a $1,000 flat fine, no minimum, punitive damages, and then attorney's fees and costs. And when we talked about earlier about these hoops you have to jump through and how it's a black and white issue, I hope you see now these really are black and white things, these 6 steps, and if you are running background checks on all of your a large portion of your applicants that come through the door, if you fail in one of those steps, it's probably going to be something that's going to be universally repeated across the board, and you can very quickly see how over a period of years these damages can very, very quickly add up. When we're talking about not necessarily damages that one can prove, but penalties such as $1,000 per violation. For a negligent violation, which after the Safeco case is going to be not a much smaller subset of violations, it's actual damages plus attorney's fees and costs, and it's really, I mean, it's the attorney's fees component that makes these cases, so lucrative for plaintiffs' lawyers to file, and why they have become, in the past, over the course of the past several years, as the statute has become more publicized, much more readily available. Why these cases have become so popular to be filed. I want to leave you with this thought, and then I'll open it to questions. So we've gone through all these, these 6 hoops you have to jump through, and why, how large the damages can be, and how these cases are attractive to plaintiffs, and by now your head might be spinning, and you might be thinking, oh my God, we don't want to get sued, and we don't want to be defending these large class action lawsuits, and why do we even have to use a third party? Why don't we just do these, just do these ourselves and avoid the whole, and avoid this whole statute, avoid this whole mess? I started with a story. I want to end with a story, and then I'll open it up to questions. And the story I want to tell will illustrate why I don't think doing these checks yourself is a good idea. It's got nothing to do with the Fair Credit Reporting Act at all, but it actually has to do with statutes like Title VII, discrimination, liability, and what have you. Lawyer by day, dad by night. I have 2 kids, an 8-year-old daughter and a 6-year-old son. And my 6-year-old son was born with a genetic condition called Noonan syndrome. And almost 4 years ago to the day, he was hospitalized in the Cleveland Clinic after a procedure he underwent went badly, and he had some pretty serious complications that developed, and he was actually in the Cleveland Clinic for 19 days back in February of 2011. And while he was in the hospital, Valentine's Day happened to occur, and so I'm sitting in the hospital on Valentine's Day thinking, all right, so this is a pretty lousy situation. We've been cooped up in the hospital now for a couple of weeks. My wife and I kind of going back and forth. One spent the day with Donovan, and the other took care of Nora, our daughter, at home. And all right, so what can I do nice for my wife for Valentine's Day that won't that I can do from the hospital? And so what gifts can you buy when you're stuck in a hospital? Well, I really didn't think my wife wanted hospital flowers, number one, or two, a nice Cleveland Clinic sweatshirt to memorialize the great time we spent together in the hospital with my son for 3 weeks. And so, as Laura mentioned in the beginning, I'm a blogger. I've been blogging now for 8 years. And so I thought, wouldn't it be nice if my wife, who at the time was a stay-at-home mom, had her own blog to reach out to other parents that were kind of going through the same kind of medical issues that we were going through with our son. And so I sat on my laptop in my son's hospital room at the clinic and set up a blog for her, and that was her Valentine's Day gift that year. Fast forward a couple of years from there, where she had been blogging fairly regularly. Both my kids were now in school full-time, and my wife, lo and behold, decided she was ready to go back to working full-time and not being a stay-at-home mom anymore, and then re-enter the workforce. If an employer did what I call the Google background check, that is the background screen that where you just, instead of hiring an agency to go and gather background information on an applicant for you, if employers simply said, you know what, we don't want to mess with the Fair Credit Reporting Act, we don't want to mess with all these hoops we have to jump through and risk getting burned by missing one of them and getting sued for a background check where really we've done nothing wrong other than some ticky-tack violation of some pain-in-the-butt statute, we'll just type Colleen Hyman into Google, that's my wife's name, and we'll see what pops up and see if there's anything we can find that would disqualify her from employment. If you type my wife's name into Google, I am fairly certain that you will find her blog. It would, and if you read her blog, if you were a prospective employer considering her for employment, you would read all about my son, his medical issues, doctor's appointments, what have you. which may, if you are not the world's most family-friendly employer, or maybe even if you are, if you have two applicants side by side, one that has to juggle these medical issues at home versus one that doesn't, I can guarantee you that one that doesn't, rightly or wrongly, is going to be on paper look like the better applicant for the job. And if you don't now hire this person based on information, publicly available information that you find online that may give you an insight into information that would otherwise be protected by the federal EEO laws, whether it's the individual's own disability medical issues, family members' medical issues. There's the Genetic Information Non-Discrimination Act, which would apply in my family's particular case also. You may find information about what church someone belongs to. Maybe someone belongs to some fringe church that you just think is weird, and you don't want them in your workplace kind of spouting off what you think might be religious views that some might not find, that some might be offended by or might find inappropriate. You may not consider any of that information at all, but the reality is the bell's now been rung. And once that bell is rung, if you don't hire the person and they sue for a failure to hire discrimination claim, you're now in the position of having to prove a negative. That is, that information did not play a role in our decision not to hire the person. And so, for that reason alone, I think these background checks are best left to the professionals, and the DIY stuff should be left to, hanging up shelves around your house, and should not be brought into your hiring process. The pros know what they're doing. The pros know how to run these checks. The pros know how to screen out information that you shouldn't see. The pros know the steps that you need to follow under the Fair Credit Reporting Act to make sure that you're doing these checks the right way so you don't get burned. Leave it to the professionals, and I could not counsel you more strongly enough to avoid the urge to do these things yourselves. And so with that, I thank you all for your time this morning. I know we went just about an hour with the presentation, but I do want to open it up to questions. You've got free lawyer time, which is hard to come by. So if you have a question, by all means, fire away. Thank you all very much.
All right, John, thank you very much. We do have several questions from the audience. First one is, what is evergreen? So if you could touch on what an evergreen release is, what it means, what it does.
Oh, yeah, I'm sorry. I should have been more clear, and I apologize. By evergreen, I mean the release basically lets the individual know that the authorization they are giving you is not just for a one-time background check, but it covers basically the duration of their employment. You would say that I authorize, when I hereby authorize XYZ company to, obtain a consumer report from a consumer reporting agency for an employment purpose at any time during my employment, pre-hire, post-hire, whatever. It is going to allow you, if you want to check someone's criminal history 2 years after you hire them, it's obviously much more standard to run these checks during the hiring process, and individuals, applicants, I think, understand and in a lot of cases kind of expect this stuff's going to be done before they're hired. During employment, if you all of a sudden say, I want to run a criminal background check on an employee, it's going to raise a lot more red flags. What are you looking for? Why are you investigating me? Whatever. And by having that evergreen release in your pocket, you don't need to tip someone off that you are running a background check on them during their employment.
Okay, thanks. Next question. Our employment application has a section that addresses that we do background investigations, but we also provide applicants with a completely separate document informing them we'll perform a background investigation and get their signature on that notice. Is it okay if we keep the information on our employment application, or do we need to revise the application?
No, as long as you don't need to revise your application, as long as the applicant is receiving a separate standalone document with a clear and inconspicuous notice letting them know about the background check. It's okay to give them the information twice, one time being on the application, provided that they get it a second time in a notice that's lawful under the Fair Credit Reporting Act.
Okay. Next one. Does it matter if the pre-adverse action and the adverse action letter are sent via mail or via email? Is there a preference, or is there a better way of doing it?
There is no preference. If you send the pre-adverse action notice via mail, snail mail, my recommendation would be to do it certified so you know that the person gets it, and then you can properly track the 5 business days. At least with email, you can send a return receipt. It's immediate delivery. If your goal is to make your hiring process as quick as possible, so you don't have to wait around, you really want to, my recommendation nowadays is to do this by email. It's the easiest, quickest, simplest way, and it gives you a means to immediately track whether something was delivered to the individual. Otherwise, if you're going to send it by regular mail, I would absolutely do it by certified mail, so that you have a means to track that the document was delivered to the person, or by overnight mail. But certified mail and overnight mail, there's costs involved with that, and so not just from an ease of use standpoint, but from a cost standpoint, if you have to send a certified letter or a FedEx every time you have to send out a pre-adverse action notice, you're adding costs into your hiring process, where email will accomplish the exact same thing free of charge.
Okay. Next one. I regularly contact someone to communicate we have received a background report and are considering adverse action and will be providing documentation to them. I then send the documentation and wait the 5 days before moving to the final adverse action. Is it better not to contact the candidate by phone first and just send out the paperwork, or what do you recommend?
It depends on how you say it. I mean, if you're saying that we have received the background information and we are considering taking adverse action, there's no indication there, in my view, that you've made up your mind, that you have what courts look for with this pre-adverse action notice is it a fait accompli? Have you made up your mind? Has the decision been made not to hire the person? And if the communication is, we've received your report back and we are considering not hiring you based on information we've received, then the adverse action has not been made. And so if the adverse action has not been made, then at that point you are still okay to send out the pre-adverse action notice. So I don't see any problem with that.
Okay.
I'm not. I just want to make clear. I'm not saying that there's not a court out there that hasn't taken a contrary view, but from what I've seen under the statute, I have not seen a case where letting someone know that you are considering taking an adverse action is deemed to be an adverse action in and of itself.
Okay. Next one. We have a candidate who has said yes to a criminal history, and we've done the background check. We're not going to go forward and make the hire because of the criminal check. Do we still need to send the adverse action because they did tell us about the criminal check or the criminal record, or are we okay without doing the adverse action then?
Yeah, you're okay. If you're making the decision solely based on them checking the box on the application, you're okay because you have not engaged in any conduct under the Fair Credit Reporting Act, because the Fair Credit Reporting Act is only going to apply when you are getting a consumer report from a consumer reporting agency. And so if you've ordered a criminal history from an agency to confirm whether or not this person really was convicted of a crime, then it's a different story. But if you're making the decision solely based on them checking the box on the application, then you've not triggered the Fair Credit Reporting Act. The EEOC still might take issue with your process because maybe you haven't engaged in this individualized assessment of what the crime is and whether or not that crime really has disqualified the individual from employment. But under the Fair Credit Reporting Act, you've not triggered any of the requirements that would require you to follow any of the steps under the statute.
Okay, we're going to do 2 more questions that we have here. If we pull the criminal checks directly from our local county clerk, do we still have to follow adverse action if we don't use a background screening company?
No, you do not. If you are pulling it directly from a county clerk, then you have not triggered the statute because you're not using a consumer reporting agency to gather and provide the information. However, I would again caution against the DIY because, you know, how many counties are you searching? Are you sure you're getting all the information? Are you, are you capturing aliases and other addresses someone might have lived at? Are you sure the individual is the person that, are you sure the record actually corresponds to the individual, or how many other people in the county could there be with that name? There's a whole host of reasons why even, I understand these are publicly available records and you can go right online and pull these records yourself and kind of do your own criminal background search and avoid all these problems. But if the goal is to get a complete picture on the applicant before you make a hiring decision, the best and really only way to make sure you're doing that is by going through a third party. So you kind of have to weigh the the cost benefit of how much information do we really want? Are we sure the information is accurate? Versus do we want to do everything we can to verify that we're getting correct and comprehensive information?
Okay. There's two similar questions we have. If you're a staffing company running a background check for your client that you're placing people, or if you're an executive search firm that's placing people, if you are making your decisions based on what the actual employer would be using as their criteria for a background check, what rules do you have to look at? What legal considerations do you have to have if it's going to be there's another layer in between BackTrack and then the final client?
So the staffing company is retaining, as I understand the question, the staffing company is deciding who to place, and they are engaging BackTrack to run certain, to run background checks on individuals, and then they're going to use that information to decide, who to send off to a particular company to interview. Correct. Yeah, I think the rules will be exactly the same because you're still, you're still, using information for an employment purpose. Yeah, I think the rules in that case would be exactly the same.
Okay. There is one question that I can answer. Are the BackTrack forms considered evergreen? Yes, our released authorizations are evergreen. So if you're using one of ours, it is evergreen. All right. Thank you, John. Thank you so much for doing this. We really appreciate it.
My pleasure.
We have recorded this. It'll be available on the website. We'll notify you when it's ready. And stay tuned. We're going to be hosting another one of these webinars in April. So thank you again, and we appreciate you listening. Bye-bye.